Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this live legal education content, and today will be the day I earned that subscription. And how, in this case, because we are going to be reading the sentencing transcript from the case of United States of America versus Wesley Hawkins. Who is Wesley Hawkins? Well, the name Wesley Hawkins may or may not sound familiar, but perhaps the name of Judge Jackson will sound familiar. Judge Ketanji Brown Jackson of the D.C. Court of Appeals, formerly of the D.C. District Court, current nominee to be the next Supreme Court Justice of these great United States. Judge Jackson, as a district judge, where she was for many, many years, before being elevated to the Court of Appeals and now to the U.S. Supreme Court, had an opportunity to sentence many criminal defendants. One of these criminal defendants was Wesley Hawkins, who was an 18-year-old who was in the possession of some fairly serious images and videos of prurient and violently prurient nature of young children, including those as young as the age of 8. The sentencing guidelines recommended a sentence of 8.5 to 10 years. The U.S. government said, how about 2 years? And Judge Jackson, judge of the D.C. District Court, judge of the Court of Appeals of D.C., and soon to be justice of the U.S. Supreme Court, said, how about 3 months? How about the 3 months for the possession of the images and the videos of the young children, some as young as 8, involved in the prurient and violently prurient acts? How exciting. Now, I, along with other people, have been a bit skeptical of this because, as it turned out, in 100% of cases involving CP, Judge Jackson went below guidelines. In some cases, well below guidelines. In this particular case, 96% below the guidelines. Because that would be what 3 months out of 8.5 years is. It's 4%. So 96% below the guidelines. And in 100% of cases involving the CP, she went below the guidelines. And we said, a lot of us said, well, that's odd. In 100% of the cases below the guidelines, including a 96% reduction of time, seems like a lot of reduction. But the problem was your friend, Uncivil Law, was unable to bring to you the words of the judge. Very disappointing, because it was all under seal. The sentencing memorandum was under seal, and the transcripts were under seal. So I couldn't go through the judge's analysis because, I like to be open-minded, you like to be open-minded, and maybe when we consider what the judge considered, maybe we would say to yourselves, you know what, you're right. That 3 months, that 96% reduction, boy, oh boy, man, I'm glad I've had the scales drawn off my eyes. I don't know how I could have seen it any other way, man. Judge Jackson, this truly was a just and judicious sentence. Who was I to ever question you? Now the truth has been laid out. But I couldn't do that analysis because I didn't have it. But now I have it. Now I have the transcripts. I have the sentencing transcript for you. I like all 55 pages of it, which we are going to read. And we are going to read this, and we are going to understand the mindset of Judge Jackson. We are going to understand the things she was considering as she was considering the sentence of this 18-year-old in the possession of the images of the 8-year-olds, which she described as being a peer of the 18-year-old, with the prurient and the violently prurient images. And we're going to see how she arrived at the number of 3 months. I've got a drink. If you don't, I recommend getting one. Let's get started with this. This is in the United States District Court for the District of Columbia, United States of America, Wesley Hawkins, from November the 21st of 2013 at 10:08 a.m. The reporter's official transcript of the sentencing before the Honorable Ketanji B. Jackson, who at the time was a United States District Judge. Let's read on. Criminal Action 13-244, the United States of America versus Wesley Hawkins. Cassidy Pinninger for the government. Jonathan Jeffries for the defendant. Good morning to everyone. Good morning, Mr. Hawkins. Good morning, Your Honor. We are here for the sentencing of the defendant, Mr. Wesley Hawkins, who on September the 5th pled guilty to one count of possession of the CP in violation of law. I did not take your plea, Mr. Hawkins, as you know, but I'm familiar with this matter because I've read and received all the related materials. And that includes a letter from you and the other notices that defense counsel submitted to the court over the last few days. I want to acknowledge at the outset that I have received and reviewed the pre-sentence report and sentencing recommendations of the probation department. I have also received and reviewed the sentencing materials from the government and from the defendant, which address the pre-sentencing report, among other things. First, I'd like to get a clear sense of the parties' views of the pre-sentence report at the outset. So I'm going to ask counsel, are there any objections to the factual recitation in the pre-sentencing report, which includes a notation about defendant's view of the limited distribution conduct in this case? Ms. Pinninger, no, Your Honor. The government does not have any objections to the statements of facts. Thank you. Mr. Jeffries, no, Your Honor. And I think the reference to distribution is probably best seen as more of a Booker argument that under these circumstances, and you know, we've met respect to a lot of the guidelines in this case, but specifically with that, it's just kind of, I mean, it was strictly to a police officer at his behest. So I just wanted to make that notation as different from some of the other cases. So it's not really distribution of the CP, you see, because it was only to the undercover officer. Okie doke. While you're at the podium, let me ask you about the guidelines calculation in the pre-sentencing report. Do you have any objections to that? Mr. Jeffries, no, that's correct. Okay, Mr. Pinninger, do you have any objections? No, Your Honor, no objections. Okay, thank you. It appears the parties have no objections. Mr. Jeffries, that all? Mr. Jeffries, yes. The court, thank you. Okay, so we have no objection to the pre-sentencing report from the probation office. We have no objections to the guideline calculation range because, I mean, the pre-sentence, they do a good job. The probation office does a good job, but of course, they could be wrong. I mean, the judge is, of course, the ultimate determinator of these things. So, you know, you could say, you know, hey, they made a mistake. But no, we're kind of happy with it. We're kind of happy with the, you know, at least the calculation of it. Okay. The court. Thank you. You can be seated. It appears the parties have no remaining objections to the guidelines calculation. In light of the facts of the case, and the final report is complete without any information excluded. Now, to you, Mr. Hawkins. This sentencing hearing will essentially proceed in 4 steps, many of which might seem a bit mechanical to you. But I want you to keep in mind why we're here at this moment and the gravity of the situation. I feel the gravity from all the way over here, let me tell you. You have committed and pled guilty to conduct that constitutes a federal crime. Today's proceeding is a serious matter because it's fundamentally about the consequences that you will face as a result of your decision to engage in criminal behavior. The first step, which I've already begun to engage in, is for me to determine whether you have reviewed the pre-sentence report, resolve any outstanding objections to the report, and I understand there are none, and then to adopt or reject the report as the court's finding of fact in this case. The second step is to determine what sentencing guidelines and sentencing range applies to your case based on your criminal history and considering any mitigating and aggravating factors under the guidelines. This the court has to do, notwithstanding the fact the parties in this matter have looked at the guidelines range and find it to be appropriate. Right, I mean, it is the court's independent responsibility to look at it no matter what the parties say. True. The third step is to hear from the government, from any victims, from your counsel, from any witnesses you might have, and from you if you wish to be heard in this sentencing and sentencing in this case. And the last step requires the court to fashion a just and fair sentence in light of the factors set forth in the statute. As part of this last step, the court will actually impose the sentence, along with other required consequences of the offense, such as a term of supervised release. So moving back to the first step, which are related to the pre-sentencing report, I understand from the parties that there are no objections. Mr. Jeffries, has your client read and discussed the pre-sentencing report? Yes, Your Honor. Mr. Hawkins, do you have any objections to the final statements or determination in the pre-sentencing report? No, Your Honor. And have you had a chance to thoroughly review the document with your counsel? Yes, Your Honor. And are you satisfied with your counsel? Yes, Your Honor. Okay, you may be seated. Hearing no objections by either side, the court will accept the factual recitations in the pre-sentencing report as undisputed. So those are facts now, including like the 8-year-old and the 10-year-old and the 12-year-old and the images and the videos involving the prurient and the violently prurient images involving all that stuff. Those are all facts now. Okay, great. Now, moving on to the determination of the guidelines. The pre-sentencing report lays out the Prohibitions Office calculation of the advisory guidelines range that applies in this case. My understanding is the calculations was done using the 2013 Guidelines Manual, which, makes sense since it's 2013. And it as follows. The pre-sentencing investigations found that you, Mr. Hawkins, have no prior convictions, and that puts you in criminal history category number 1. The applicable guidelines in this case are in the relevant statute, which for this offense of conviction have a base level offense of 18. All right, so this is how we calculate how bad this crime is. All right, so what they're doing now, just so we can talk to you a little bit about what's happening. First of all, we have a how bad have you been up to this point, right? How much bad stuff have you done up to this point in your life? He has done no bad stuff, or at least no bad stuff he's gotten a conviction for. So he's in category 1. Easy peasy, no dispute, right? All right, now, so that's part 1. And I believe there are 6 categories of bad, depending on how bad you've been in the past. I believe there's 6 categories. He's in category number 1. Okay, great. Now we have to determine how bad this particular offense is, right? So the nature of the offense has a baseline number, which obviously depends on how serious the offense is at base. Murder is going to have a different baseline offense than, a robbery or something else, right? Obviously. So there's a baseline number, and then there's a whole bunch of numbers that add to and subtract from that number based on things that aggravate or mitigate. And these additions are in the guidelines. So they're not just pulled out of your ass, right? There's a way to calculate this, and the judge is now going to go through the calculation with us together so we can learn just how bad this particular crime is based on the guidelines. Great, let's do that. All right, so the baseline offense. I've got a drink. I've got it. Okay, so the baseline offense is category number 18. The pre-sentencing report increases for 5 different specific offense characteristics for a total offense level increase of 15, which brings the offense level to 33. The government has also requested that you, Mr. Hawkins, have demonstrated acceptance of responsibility in this manner that entitles you to a 3-level reduction under the relevant guidelines. Therefore, prior to considerations of departures or variances, the total offense level under the guidelines is 30. I just want to be clear for the record, are there any objections to either the criminal history calculation or the guideline offense level? All right, so this is level 30 bad. Not from the government, not from the defense. Thank you. Now, at this point, I'd ordinarily turn to possible departures as a second stage of determining the appropriate guidelines calculation. But this case involves an offense related to children. And thus, as a result of the PROTECT Act, it is my understanding that no downward departures within the guideline framework are authorized in this context. Is that your understanding as well, counsel? Your Honor, we agree not to move for departure. I know that much. Okay, all right. Ms. Pinger, I believe that's correct, Your Honor, but I've not reviewed this portion again this morning to confirm that. But I believe that's correct, and the parties have agreed that neither party will seek departure. Okay, so the parties have agreed that neither party will seek a departure down from the guidelines range, right? They're just agreeing as to what the guidelines range. That ultimately doesn't constrict the judge, as we will well learn, but they're not going to say that we're seeking a departure from the guidelines. So they're agreeing to level 30 as a guideline. Great. The reason why this was significant to the court is the guidelines now recognize that age, and age of defendant may be relevant as a departure consideration when it's present to an unusual degree. But this consideration has not been specifically applied by the Commission in the context of these offenses, nor has the Commission determined that age of the offender wasn't taken into account when the CP guidelines were crafted. So I just want to put on record that this court is not considering age a departure factor at this time. So the final guideline deadline range, the court concludes, as given offense level of 30 and criminal history category of 1. The range is 97 to 121 months of imprisonment. I want to read that again. So the final guideline sentencing range, the court concludes that it is given an offense level of 30 and a criminal history category of 1. The range is 97 to 121 months of imprisonment. And they agree to that. Everyone agrees to that. Everyone agrees that is the guideline range for this offense. 97 to 121 months. And as I pointed out, not so much with the, and as I pointed out, not so much with the 97 months, but how about 3? How about 3? Which means it's a 96% departure from the guidelines range, because that's what 3 out of 97 is. Okie dokie. Under the guidelines, Mr. Hawkins also faces a supervised release range following imprisonment of 5 years to life and a fine range of $15,000 to $150,000. I want to pause for a moment to discuss the supervised release term. Because this is considered a sexual offense, the applicable supervised release term, as I've said, is 5 years or 60 months to life. I'm sure that your lawyer has explained this to you, Mr. Hawkins, but I want you to understand that supervised relief is a period of time that is served by the defendant after the term of imprisonment, in which the defendant is under direct supervision of probation office, and defendant is required to follow a number of conditions, primarily for rehabilitative purposes. In sex offense cases, Congress and the Commission require very long periods of supervised release because they want to ensure the defendant gets treatment and the public is protected. If the conditions that the probation office, that the court imposes, and that the supervision by probation office are not followed, a defendant may be returned to prison in a supervised release context. Do you understand this, Mr. Hawkins? Yes, Your Honor. I apologize, Your Honor. That's okay. Thank you. You may be seated. Moving to the next stage, before I discuss the sentencing factors generally under the statute, and those will bear on the court's final decision, I'd like to give the parties an opportunity to address the sentencing guidelines calculations, or anything else at this time. So, Mr. Pinger, does the government Miss Pinger, my fault. So, Miss Pinger, does the government wish to speak about the application of the factors set forth in the statute at this moment? Yes, Your Honor. Thank you, Your Honor. I submitted a written memorandum in aid of sentencing, and don't wish to repeat all the things I set forth there. I think the government certainly has a lot of disagreements with certain arguments put forth by defense. We disagree, for instance, with some of the specific arguments about the guidelines calculations in this case. We believe that enhancement for distribution, which, again, he did, but to a police officer, so it's totally okay. The defense distribution here, although post hoc, is categorized just as sending something to an undercover detective. The defendant, of course, didn't know that. At the time, he believed that he was sending CP to an individual he had met online. We believe those enhancements are appropriate. We believe that although there are certainly criticisms of non-production CP guidelines that have been made by the Commission, and defense isn't disputing this, the guidelines calculation should be calculated under guidelines as they currently exist. I mean, that would kind of make sense. And we do believe it is relevant to consider some of the criticisms that has been lodged at the guidelines. For instance, one of the criticisms is that the specific offense characteristic enhancement, based on the number of images, doesn't adequately distinguish between offenses. The government recognizes that consideration, but doesn't believe that it means it's appropriate to just disregard the number of images, that the number of images can be appropriate, and indeed, in this case, the government amassed an extremely large collection of the CP. I am saying all this, sort of with a caveat, because we believe that nevertheless, despite some of our very strong disagreements with the positions on the guidelines and with enhancements that may apply, or the way in which this offense can be characterized, including sadomasochistic images, just because they are more prevalent in society doesn't mean their possession is not harmful or heinous or shouldn't be punished. The sadomasochistic images of the children. Nevertheless, in the specific circumstances of this case, the government is recommending a below-guideline sentence as a variance, and we're doing that based on some very specific characteristics, one of which is not just the defendant's age, but his experience and discussion that, as put forth in the expert report that was submitted by the defense. The government has read and considered it, and again, we have some disagreements with it. We don't believe the risk assessment instrument that was used was appropriate, given the facts of this case, things like that. Nonetheless, we've tried to analyze this particular defendant's conduct. We've attempted to look at his case in light of all other cases, and we could identify that we believe a comparative in this jurisdiction. And the government has also, in this case, submitted, I believe, it's just one victim impact statement that has been submitted by the victim of one of the images the defendant possessed. And the government believes that when the court considers all of those things and the very unique circumstances of this case, notwithstanding all of our disagreements with the defense, that we do believe a sentence of 24 months here is appropriate. And that would take into account the very serious nature of the crime, the very serious nature of defendant's conduct, but also take into account his personal characteristics and the psychosexual evaluation that was done. Some of the things he struggled with, some of the context and explanation for how this crime came about, but also recognize that this was repeated conduct. This was conduct over a long period of time, and this is very serious conduct that is harmful to our society. So unless the court wishes me to go into some of those disagreements in more detail and our positions on them, the government believes that under the unique circumstances of this case, we don't need to go into them. The court, let me just clarify a couple of things. Certainly, sure. One of your statements is that the defendant had amassed a large collection. And I understand that under the guidelines, the way the table works, videos count as a certain number of pictures. But in the pre-sentence report, factual recitation I've adopted, it appears as though it was 16 pictures and 17 videos. "16 pictures and 17 videos with the sadomasochism of the children. "16 pictures and 17 videos with the distribution to the undercover detective." Okie doke. Is that your understanding of the collection? That's correct, Your Honor. But the way it works under the guidelines and enhancement for number of images, it enhances it for more than 600 images, which is obviously more than 16 plus 17. And that's because each video, the way the guideline treats it, is the equivalent of approximately 75 images. Which, I mean, it's a video, so the court, right. And so 17 videos is a lot. And some of those videos, including the one that are described in the statements of offense, are very lengthy and include, you can have one image, but if you have a video, you have numerous images, numerous views, sometimes collages, sometimes mobile victims. You see the act in progress. When I say a large collection, that's accounting for the large number of videos. It is, and it takes it into account. I guess the guidelines view is the video is in some regards worse or more harmful to society, or more harmful to the victims than just an image, although both certainly are bad. The court, and let me ask you another question about the statement you've made. Certainly. At the end, you mentioned that this was a long period of time, and I just want to clarify your understanding of when the conduct began and when it ceased. Certainly, Your Honor, it was at least a 6-month period in my understanding, which is just to say, certainly this can go on for much longer, and there are certainly defendants in this courthouse who have been engaged in the conduct much longer. But I guess my point is that we repeated the conduct over several months that began in December. There were additional instances that had been flagged by internet service providers in January. There was contact with a detective in February. There was, again, later contact in March. There was still evidence it was occurring in June. So I guess my point is it was repeated and continuous over at least that 6-month period. And it might not seem like that long, but I guess the point was it just wasn't something that just happened to be upon just before this happened. It's been going on for a period of months. I understand. Thank you, Ms. Pinger. Thank you, Your Honor. Mr. Jeffries, would you like to speak on the defendant's behalf? Yes, I would. Your Honor, this is an extremely difficult case in some sense. I want to emphasize, I think, at the outset, how unusual this case is for federal court in terms of Mr. Hawkins' youth and inexperience. There are other factors that make it unusual as well. The relatively low level and sort of episodic involvement in this, which I think actually compares. Your Honor asked the government about that, but I think this actually compares very favorably to other cases in this district in where the defendants have gone probation. Which might be true, and also a little bit scary. Who knew the possession of the CP wasn't that big a deal? But just overall, Mr. Hawkins, you know, I've done a number of cases in the last 9 years, and I've seen my colleagues do many more of these cases. And just in terms of number and strength of mitigating factors in this case, I don't think I've ever seen a more compelling case for a sentence that does not involve prison. I think that one thing that really speaks to how unusual this case is in for the government, you know, for something we're thankful for, they did not ask for Mr. Hawkins' pretrial detention. They thought he was safe in the community under appropriate supervision all this pretrial time. And their faith in him has been rewarded, and the court's faith in him has been rewarded by the fact he's been 100% compliant with all the terms and conditions of the most restrictive forms of release, which is a high-intensity supervision program. But more than just the government's decision to leave him in the community is the substantial, that they moved him substantially away from the guidelines in terms of recommendation here to the court going forward. You know, I disagree with their recommendation strongly, obviously, but I think it's about as low a recommendation as you're ever going to see or I've ever seen from the government in a CP case. And I think that speaks volumes that they're asking for something so low. I've seen one request that low involving cooperation, but I've never seen a guidelines case that I've seen the government come in at such a low level. I think that speaks a lot. I think they're as low as they're going to get. And I think what they've given in part is what Ms. Pinger said, which is that Mr. Hawkins is the youngest defendant I've ever had in federal court. We don't get people of his tender age here. Mr. Hawkins might be of a tender age, but you know who's even of a tenderer age? Yeah. Just a reminder to everyone, if you are liking the fact that I'm covering this in any way, I'm assuming this video is very, very demonetized. And it is discouraging because I want to bring content to you that I think is important. So if you're getting any value out of this in any way, by hearing and listening and seeing the words of this, I would appreciate your support. Carrying on. Anyways, I don't know why that is, In drug cases, I think they don't bring them over here. In this type of case, I don't know if there's some level of an idea that these cases are thrown back. I don't know if that's what goes on. Your Honor, obviously that train has left the station at this point, but I think there's very compelling arguments that this would be one of those cases. It hasn't been, so I think we're left with what we're left with. So his argument is it shouldn't have been prosecuted at all. Okie doke. But I think, like I'm saying, this case really stands out even when compared to other probation sentences in this court on the CP matters, such as Maria and Malkov. These are in your sentencing memorandum? Yes, Your Honor. The James Wright case, probation. And then also cases from other circuits that involve probation, like the Polito case, where a probationary sentence was upheld in this circuit. This case compares favorably in terms of strength, mitigating evidence, even compared to probation cases. So I've really never seen something as compelling as this. And I think with all respect to the government, a sentence of probation, a sentence of prison in this particular case with this particular defendant would be very destructive and would not serve anyone's interest. It really would be a lose-lose. I think one of the most poignant things about this case is that Mr. Hawkins graduated from Booker T. Washington Charter School with awards, certificate, great awards from teachers, his counselors. I mean, just all around what you're supposed to be doing, and got scholarship, $4,000 in scholarship money, and was accepted to attend Shaw University in North Carolina. And because of this case, that's not going to happen. Now, I know, oh no, I've been remiss not to introduce all the family members. $10 from Nate Moe, and KBG is in the mainstream when it comes to sentencing. Vile, awful crap. Respect. Could you stand up, Miss Grazzi? That's Mr. Hawkins' mother. Then we have his aunt, his uncle, and a cousin, and a lot of people here in support of Mr. Hawkins. And I know his mother wants to address the court before sentencing. So what can we do? College is obviously something for this family, for this particular defendant. That's a dream, you know. And I think it's a dream that if you ask anyone in this courtroom, I know Ms. Pinger would think so, that's a dream that we hope we would all realize. And so what I'm going to do here today, though, may be make or break in terms of that dream, to be honest, Your Honor. And I'm going to get some of the collateral consequences and what I've seen in those cases later. How Mr. Hawkins got a job with an IT company. Isn't rehabilitation what you conservatives always talk about? Well, as an IT company, it seems deeply questionable to me. I mean, I'm all about rehabilitation and second chances and all, but seeing as his conduct directly involved computers and the CP on computers, the fact that he rehabilitated himself by getting a job in IT is not particularly encouraging. Second, rehabilitation is a worthwhile goal, but not without, appropriate recompense for the wrong. So, I mean, the 3 months seems a little light, in my humble opinion, in sort of one of the many goals of criminal justice is reciprocity. And 3 months for the possession of the 16 images and 17 videos with the sadomasochistic images of the children and the child rape. Yeah, I'm not feeling it. And then they put him in IT. I'm like, I'm yellow, not red. Oh, that's good news. This case is about an 18-year-old looking at his own age peers. If 8-year-olds are peers of 18, then sure. Yeah. I'm going to need more tequila. I do think what we want to do is point him on a path towards college education. I think given everything else he's going to have to deal with, the only way to do that is to fashion a sentence that keeps him here in the community, although still punishes him for what he did. So going back to, I think, the number of mitigating factors here we've got. First is Mr. Hawkins' youth and also vulnerability. And I think, submitted that notice yesterday. I really should have addressed that more, the second issue. I should have addressed that more in my sentencing memorandum, but I think Your Honor understands our arguments are on that. So, I also want to address his low level of culpability. Really? And I think Your Honor just got at it with two very poignant questions to the government about this case compares to other cases in terms of volume of the collection, and also the frequency and length of time. Third would be reasons for his involvement in the offense activity, which I think is what Dr. Guinta's report gets to, which are really different in this particular way from what we generally see in these cases. It's not just the reasons we see in the typical case. It's far more complex, I think sympathetic and mitigating in terms of the sentence, which are the reasons for doing this. And finally, I want to talk to the consequences of this conviction. The youth, I think, we talked about it in length in my memo. But like I said, I've never seen a defendant this young in one of these cases, in this court, in any that I've known, not just in my cases. And what we've submitted, the Supreme Court cases we cited and other cases, is that youth makes him less deserving of punishment. And I think it's well established in the Supreme Court now, in the whole series of cases involving other issues. But his youth, however important it's been, in terms of viewing it as a mitigating factor. He needed a night with my Green Mile eyeball. Cute. I think even more true in this area, sex, where, you start off. People are very confused at this point in their life about these issues. Now, obviously, something went very wrong. When the sex is with the 8-year-olds, yes. For wrong, and I'm not all diminishing the seriousness of what happened. You are a little bit, to be honest. But you start off with people. A lot of people have problems with these issues at this age. I think in this particular area, youth is all the more important. And this just goes into, I think, what Dr. Guinta just said about what he was doing when they did that, which is I'll address in a second. But the other thing, what youth is, we have to think about how this will affect the rest of his life. There are a lot longer to live, and there are a lot more damage that can be done by this conviction. And I just think with all the other consequences that I'll talk about, this is the way we can get him back on track for the rest of his life, to make sure it's a life well lived and can make amends for this mistake, is not by incarcerating him in a federal prison. Since I've already graduated college and law school, I have three university degrees because I graduated undergrad twice. So since I graduated undergrad twice and law school, and I have 3 degrees, how much CP can I download? Do I have like an allotment built up because I've already gotten a college education? So is there an amount of CP I can get that will be balanced off by my education? How much CP am I allowed to download? And is an 8-year-old my peer too? I feel dirty inside even asking those questions as a joke. Ugh. Okay. $50 from Nate Moe. Thank you very much for $50, Nate Moe, for helping to balance out this horror show. What about his victim's future? Maps belong on the wall. Yeah. What about his victim's future? What about the 8-year-old and the 10-year-old and the 12-year-old with the sadomasochistic rape? George Carlin wouldn't even joke about children in this way. I mean, yeah, I felt pretty dirty inside, I won't lie. I mean, like many people, Like many people, I use comedy and humor to try to deflect and deal with evil. So the idea of like using humor as a tool to diffuse uncomfortable, it's like, but the fact that I could even make that joke at all is like even more disturbing, because of Judge Jackson knew all this. And Judge Jackson gave this person 3 months. And that's, yeah. $20 from Nathaniel Wizardcraker. Thanks, Kurt, for all you do, especially in this case, exposing what kind of Judge Jackson is. Yeah. Yeah. Not as dirty as the children felt. Yeah. There isn't any way to use humor in this. It's sad. That might be true. Carrying on. This case is a huge setback, but I think Mr. Hawkins has a ton of promise. I think my experience with him, everything I've read about him, this letter from his pastor that just came in this morning, and I apologize for getting it to your honor so late, but it finishes. I think that it says it much better than anything I could say. Your honor, my deepest prayer is that this one indecent, as serious as I know it is, it doesn't derail a promising life. I personally believe he's already been shocked and scared into a law-abiding life by this experience, and this process is before your bench today. I pray that every bit of mercy available to this court should be applied to this young man. If there's a person who belongs in college, it's Wesley Hawkins. He'll be able to do as much for his family with an education. That's pretty much it in a nutshell regarding Mr. Hawkins' future, I think. In Mr. Hawkins' letter he wrote, to the court he wrote, I hope I can make it up my mistake, and this will not end my life before it starts. I think the challenge he recognizes is that what's going on here, it's a possibility here. I think that the challenge of this case and the sentencing to help ensure it does not end Mr. Hawkins' life before it starts. On the involvement, Your Honor, Your Honor's already got it with questions, but comparing even the defendants in probation cases, his collection was smaller. His involvement in this was more episodic. And then just another factor I probably should talk about was just how compellingly unsophisticated this was. Yeah, okay. So this is a nice little detail. He uploaded the CP to the YouTubes. He uploaded the CP to the YouTubes. We're talking about using YouTube, Google, and a SkyDrive, which is a program that was installed on his computer, not something he went out to get. This is the most basic form of these cases, other than someone who has a magazine or something in print form, which we never see. This is the most unsophisticated thing I've ever seen. His email that identified with the photos were uploaded by his name, Wesley Hawkins. So it obviously wasn't very hard for the government to figure out who he was. And we know exactly how often it wasn't very... Wow, I can't believe I'm about to do this, but this is where we're going right now, guys. It wasn't very hard for the government to figure out what he was doing, because he wasn't using ExpressVPN. ExpressVPN helps hide your information from the government, so the government can't spy on you when you're uploading the CP to the YouTubes. So make sure to download from our sponsor, ExpressVPN, today. And we know how often he did it, because he used these basic sources now. Google, everything else, which this development I think is very interesting now reports. Knows what happens and reports it. So every time he did it. It was very episodic. It was several times. The government, in their complaint, in this case, they know every time he engaged in this behavior. And it's really not compared to the probation cases Malkoff. Well, Malkoff didn't know. But the other guys who received probation in this courthouse, Jason Wright, Moriera, these guys had very long collections. What's even funnier about that dark logic is that ExpressVPN isn't a sponsor of this channel. I just picked their name out of the air. They don't sponsor this channel. I just picked their name. It was the first name that came to mind, ExpressVPN. Probably not becoming a sponsor now. Hey guys, don't tell the ExpressVPN about their unintentional sponsorship. We might need them in the future. I wish I went back and looked at the sentencing memos, and they had very long collections. These were older people in their 30s and 40s. They've been doing it for a long time. And their images were far more disturbing than I think in this case. Which I think really what we had here is the people, I could chill out our actual sponsors. Try Surfshark. Which is really what we see here is that people are not much younger. Again, I know why I'm minimizing this, but not much younger than Mr. Hawkins himself, which again feeds back to Dr. Guiana's report. That really concerns me. And moving on, that really concerns why he did that. If you look at Dr. Guiana's report, which I think you know, I know a lot of times the government's skeptical of reports we submit, but this really gets it, I think. What that Mr. Hawkins, for all of his intelligence and maturity in some sense, also has maturity issues. Well, after this, after this, man, I would have a tough time sleeping. But fortunately, I have Bullen brand sheets. Bullen brand sheets are just the softest sheets you've ever had, they've ever worn. These 100% con sheets, man, they're just the greatest thing ever. Ever since I got the Bullen brand sheets, man, my sleep is so much better. And I know that I'll sleep soundly having read this because I have Bullen brand sheets that guide me there through the evening. But in any event, what we have here is I think Dr. Guino was right about this, about why it happened, which is not a 40-year-old man who's sexually exploiting these images. It's not only about that. It's also about trying to emotionally identify with what's going on here. As I said, people are very confused about sex in this age. I think it's a way of trying to understand things. In this case, it's really most Judge Huvel's case, Malkoff, and that's because of the one-off reason, I think, for what's going on here. Malkoff's case, I think it was a major factor that Mr. Malkoff was 47 at the times of the offense of the conduct, had been subject to stranger rape when he was 9 years old. And he had spent there were tons of evidence, from doctors he'd seen over the intervening 30 years, when he'd just been mentally grappling with this rape and trying to process it. And the images he looked at were a very misguided attempt to deal with what happened to him. In this case, there was a very misguided attempt to try to understand what happened to him. Very misguided. But I do think a better explanation, and I think it's accurate, but also reflects more favorably on this case than other cases. I've saved Collateral Consequences for last, but perhaps it's the most significant consideration in terms of this case will affect the rest of Mr. Hawkins' young life. No matter what this court does today, there will be enormous consequences that he'll never outlive. This whole area, in my view, it's not for today, but it needs to be revamped. You can't put people back in society but prevent them from being able to live. But the way the law is right now, that is what we do. We put them back there, and they can't make a life. Well, apparently he can. Apparently, even with a felony conviction for the CP relating to computer use, he was able to get a job in IT. in IT. And one wonders how his company came to hire him in particular for the IT job. Where are they getting these candidates? These are not the top tier candidates this IT company should expect. That's why you should use ZipRecruiter. ZipRecruiter is the best tool possible to help you get the high quality candidates that you need and help you get your next job. So you won't hire a person like Wesley Hawkins, and instead will get someone who is able to help you without damaging your company in every possible way. ZipRecruiter. Fire Wesley Hawkins and fire someone new today with ZipRecruiter. The articles of this attack show that he can't live anywhere. This is not, despite what this court does with supervised release. Municipalities, states have their own laws about sex offenders, and there's no question he's going to be a sex offender for 15 years. Probably the saddest one I'm dealing with right now is a defendant who did a year and a day, got out. He was a nurse. He was in the Army, studying to be a practical nurse. He is about to take his test for that. Now he's back out. Can't get a job at Avis as a counter guy. He can't get a job at Walmart. He can't do anything. All these years studying to be in the Army and now working to be a nurse, all these things he could have done for people who are lost. So it's not just him that loses, it's everybody. And that's going to happen no matter what today, unfortunately. And I hope someday Congress, society revisits what we're doing. But I just think we don't want him to send him back any more than he's already going to be through a sense of imprisonment. Your Honor, I know Mr. Hawkins also wants to address this court and his mother. Yes. Why don't we have his mother approach and then Mr. Hawkins? Hi, Your Honor. Good morning. My name is Erlene Grasty. Your Honor, what I want to say today, I know what my son did was truly wrong, but I don't want that to be the cause of my son not continuing his dreams and his goals. My son is very intelligent, bright, loving young man, and I know he regrets what he did, which is what he had to, and in which he had to do it over, he wouldn't do it. I just want the best for my son, like any other parent do. I know you hear that a lot about what he did was wrong, and I'm the type of parent to say when my son is wrong. I don't stand by him when he's wrong. When he's wrong, he's wrong. I just want the best for him. I want him to continue to be able to go to college, continue his dreams, and let his light shine, and do what the Lord has for his journey. That's all I want to say, Your Honor. Thank you. Thank you, Mr. Grassley. Mr. Hawkins. Hello, Your Honor. Hello. Mr. Hawkins has some comments he'd like to offer right about now. So, what will we learn about from Mr. Hawkins? Let's find out. $4.99 from Jacob Turnbow. A super chat for the super ads. I hope you got my email about some fan art I've seen. Keep it up. I did see your email. Thank you, Jacob. It was very nice. Mr. Hawkins says, first off, I'd like to apologize to my family and the court and to anyone I've hurt with my actions. I have to say I didn't know what I was doing. I'm not here to say I don't deserve punishment. We all deserve punishment. Okay. I just hope we can make amends with what time I have left. And I'll swear to you I'll never do this. I'll swear to you that I'll never do this again. I don't know. I mean, to say I swear I'll never do this again. I mean, really, I don't know how you can possibly expect the court to believe that. I mean, how are you going to conceal all this from all the people that came to you? Well, my friends, when it comes to concealment, nothing is better than Halo Beauty. Halo Beauty provides the wonderful vitamins that you need in your life to provide you the supplements and nutrition you need to really grow within. And don't forget our corresponding brand, Toddy Beauty, for makeup products for your skin to revitalize your skin. This skin you see before you has been brought about by Toddy Beauty. So you, me, and Mr. Hawkins alike, Halo Beauty and Toddy Beauty for the beauty from within. Yeah. Mr. Jeffries, do you have anything else? If Mr. Pinger wants to say anything, she can. But do you have anything else? No? No. Thank you, Mr. Hawkins. Mr. Pinger, do you have anything else? I don't have anything else. Okay. Well, I think Mr. Jeffries said it best when he said this is a difficult case in many ways. The court has had lots of considerations that take into account. At this stage, Kevin says, love you, bro, need to lose some weight. Well, Kevin, I have some good news for you, my friend. And good news from other people who are not as familiar. I am on a weight loss journey. In fact, I'm going to the gym quite a lot. I went to the gym yesterday. I went to the gym today. I went to the gym yesterday. I went to the gym the day before. And I am trying to exercise quite a lot. And I am gaining strength. So if you follow me on Instagram, you can follow my workouts. And you can follow what I'm doing to try to lose some weight. Today I did a mile, 1.1 miles on the elliptical. Yesterday I did 1.05 miles. The day before it was 1 mile. And you can see a pattern here developing, right? And then after I did my 1.1 miles on the elliptical, I did some cable biceps. I did some leg extension things. And I did some delt extensions. Those were really good. Got to get those out, Really good. So, I am trying to lose weight. And if you're interested, you can follow my fitness journey on Instagram. It's going really good. It's going really well. Do an ad for LA Fitness. "24 hours, great. They have a sauna and a steam room." That does sound pretty badass right now. Do high reps, low weight? I'm kind of going the other way, to be honest. I mean, high reps, low weight have their purpose too, but I'm kind of interested in strength. So it may not be the most optimal for weight loss, but I'm kind of going the other way with high weight, low reps, because I want to build strength, because I find it very validating. So, but thank you anyway. The court has a lot to take into consideration at this stage. At this stage, after calculating the guidelines and hearing the statements that have been made, I must now consider the relevant factors Congress set forth out in the relevant statute in order to ensure I impose a sentence that's sufficient, but not greater than necessary to comply with the purposes of sentencing. These purposes include the need for sentencing to impose, reflect the seriousness of the offense, to promote respect for law, and to provide just punishment for the offense. The sentence says, I do love how everyone has instant fitness advice. It's great. The sentence should also deter criminal conduct, protect the public from future crimes of the defendant, and promote rehabilitation. In addition to the guidelines and policy statements, I must also consider the nature and circumstances of the offense, the history and character of the offense, the purposes of sentencing, the type of sentencing available, the need to avoid unwarranted sentencing disparities among defendants with similar records who've been found guilty of similar conduct, and need to provide restitution to any victims of the offense. I've heard the statements here this morning. I've read the sentencing memorandum. I've considered all the factors when deciding what the sufficient but not greater than necessary sentence is in this case. I won't detail orally all my considerations with respect to each one of the statutory factors, but I do have quite a bit to say for the record and for you, Mr. Hawkins, about considerations in regard to the nature and circumstances of your offense, the characteristics as offenser, the purposes of punishment, and unwarranted sentencing disparities. $4.99 from Samuel Ellers, harvesting that cultivated mass. Beefcake all day. Beefcake, kick ass. Visine. Yeah, Visine, when you can't be Mirandized, that was a great one, man. Yeah. Yeah. During those times when you've been pulled aside by the police and been told that you're under arrest and you have dry, itchy contacts that prevent you from hearing your Miranda warnings, don't forget the magic of Visine. Visine helps brings out the dry, red eyes and itchy eyes so you can better hear your Miranda warnings. Visine for all your Miranda warning needs. Amoebic dysentery shifts 70 to 100 pounds in a week. That's one way to go, I guess. I want you to hear what I'm saying about these factors, Mr. Hawkins, so that you can be clear about what has affected my sentencing decision in this case. In regard to the nature of your offense, let me start out by helping you understand that possession and distribution of child pornography is an extraordinarily serious crime. I'm feeling the extraordinariness right here. I'm feeling it. It involves people who are out there somewhere taking pictures and videos of children while those children are being sexually abused and then putting those pictures on the internet for other people to see. Make no mistake, Mr. Hawkins, the children you saw in those pictures were not willing participants in the conduct that you witnessed. They are being forced to commit unspeakable acts of sexual violence for the pleasure of the person who is filming and for the gratification of sick people everywhere. People like you, incidentally, Mr. Hawkins. People who apparently have no shred of empathy for what this must be doing to children who are abused this way. Also, that would be you, Mr. Hawkins. I have heard victims of child pornography offenses talk about what the offenses do for them for the rest of their lives. And in this very case, the government has submitted a victim impact letter. Some of the children you saw in those pictures will never have a normal adult relationship. Some will turn to drugs and prostitution and other vices to try to emotionally deal with the pain that results from the torture they've experienced. And even those who manage to lead a somewhat normal adult life say they live in constant fear of being recognized. Some people are unable to even leave their houses because once those pictures are on the internet, they are there forever. And the victims can't do anything without worrying that every person that has met them has seen them in the most vulnerable state at the most horrible times of their lives. So I'm aware that you, Mr. Hawkins, did not produce any of the pictures. I've taken that into account, which is good because production is an entirely different offense. Lawyers, judges, and others who deal with this crime often distinguish between those who have taken the pictures and those who merely look at them. And there is a distinction, but in my view, that distinction may not be as great as the people make it out to be, and here's why. Because the market for producing pictures of children being molested and raped is driven by those who want to see the pictures, by people like you, for example. If the lookers weren't there, then there would be fewer child victims, which is why I believe that Congress was motivated to make mere possession of child pornography a federal offense, in addition to crimes of selling and distributing the photos, and of course, making them in the first place. There are other things about the lookers, that is, those who merely possess the child pornography, that makes some child pornography offenses especially serious. A report the Sentencing Commission issued last year, and that your counsel noted in his memorandum, found that many people who search for, possess, and distribute child pornography become serious collectors who sometimes have thousands of images that catalog and classify and cherish. Serious collectors sometimes also form communities, gathering online, in chat rooms to trade images and encourage new submissions. Well, if he didn't know about them before, he does now. And some child pornography offenders even escalate to molesting children or using photos to lure children into inappropriate sexual situations. I do note with some relief that it does not appear that any of these hallmarks of particularly egregious behavior regarding child pornography apply to you, Mr. Hawkins. Although the guidelines charge you with having more than 600 images, the court notes that your collection at the time you were caught was not actually that large as it seems, because it consisted of 16 digital images and 17 digital movie files. Now, I do note and understand Ms. Pinger's argument about the fact that videos are in many ways more egregious than individual stills. And the guidelines do take that into account. Nevertheless, the court does see a difference between 600 images and a collection of images and video files that you had. In addition, it appears that your amassing of child pornography started less than a year ago and ended with your arrest this summer. So you're only involved with this for a few months, unlike other defendants who continue in this manner for years or more. In addition, other than your engagement with an undercover officer, there isn't any indication that you were in any online communities to advance your collecting behavior. The record does demonstrate, however, that you know the difference between regular pornography and child pornography, that you're actively searching for videos featuring child sex acts, and that you... Maybe, Stephanie. There's not enough alcohol in this world. All right, we can make through it. Let's turn on my happy, cheery face. The record does demonstrate, however, that you knew the difference between regular pornography and child pornography, that you're actively searching for victims of featuring child sex acts, and that you peruse these materials using available technology and wherewithal to find what you were looking for. To assess the gravity of your child pornography offenses you've committed, your counsel suggested I discount substantially the Guideline's assessment, which is, as the government recognized, based on factors that have been widely criticized. I'm willing to do that to some extent, 96% as it would turn out, because I do think the Guideline factors are in many ways outdated and no longer adequately distinguish more serious child pornography offenders from less serious ones. For example, the Guidelines focus primarily on the number of images and use of a computer, which are hardly aggravating factors today. And in your case in particular, I don't feel it's appropriate, necessarily, to increase the penalty on the basis of your use of a computer, or the number of images or prepubescent victims, as the Guidelines require, because these circumstances exist in many cases, if not most, and don't signal an especially heinous act of child pornography offense. Yeah. I also don't know, as your counsel has pointed out, whether distribution is really a... Okay. I also don't know, as your counsel has pointed out, whether distribution is really appropriate as an aggravator in this case, because I do recognize, as the government said, that you didn't know to whom you're distributing, but there's only on record one instance of distribution. So apparently, and this is something I didn't know about, but apparently when it comes to distribution, you get a one-time mulligan. There's a mulligan for the distribution. Okay. The long and short of it is that the first factor, the nature of the offense, I believe you committed an extremely serious crime. I feel the seriousness radiating all the way over here, guys. I am bathed in so much fucking seriousness, I can't even tell you. The amount of seriousness I'm feeling radiated over here is like an atomic bomb. It's just so much seriousness. I can't even believe the seriousness I'm fully experiencing at this moment. I also believe the current guidelines offense overstates the seriousness of your conduct and prescribes an offense level that's out of proportion to the actual offense you've committed. You know, my friends, from time to time, I find myself completely exposed to the elements. And this might have happened to you too. And you're like, I don't know what to do about this. I'm completely exposed to the elements. I feel so vulnerable. Well, not to worry. I have this all new product for you. It's called Wall. Wall is the all new product that helps protect you from the elements. With my all new product Wall, you will be protected from the elements. And you will have a place to put all the maps. So many maps you have in your collection you don't know what to do with. This is a problem I have in my life. I have so many maps. I don't know what to do with them all. But I have all new product Wall. Carrying on with the wise woman's words, the long and short of it is, I believe, the first factor, the nature of the offense. I believe you committed a very serious offense. Moving on to the next factor, your history and character as an offender. As defense counsel noted, there are many mitigating factors that relate to your personal characteristics. One is your age. You were only 18 when you committed this offense. Most child pornography offenders are middle-aged adults who are deviants, drawn to pictures of vulnerable children and these disgusting images of children's sex abuse case. This case is different because the children and... I swear I can say this with a straight face. I can do it. I can say it with a straight face. Okay. This case is different because the children in the photos and videos you collected were not much younger than you. This seems to be a situation in which you were fascinated by sexual images involving what were essentially your peers, which I believe both counsel have recognized makes this a different circumstance than the ordinary child pornography case. I'm sorry, I totally blacked out. I totally blacked out. Oh, okay. Well, this portion I haven't read before. Let me read it and see what it has to say. This case is different because the children in the photos and videos you collected were not much younger than you. This seems to be a situation in which you're fascinated by sexual images involving what were essentially your peers, which I believe both counsel have recognized make this a different circumstance than the ordinary child protection case. Da 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 da. Da 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 One more time. One more time. $123.45 from Lamb Chop. Build a wall, big beautiful wall. Thank you, Lamb Chop. This case is different because the children in the photos and videos you collected were not much younger than you. This seems to be a situation in which you were fascinated by sexual images involving what were essentially your peers, which I believe both counsel have recognized makes this different circumstance than the ordinary child pornography case. I will say I've done my research in this regard, and in that response to Mr. Jeffrey's representation about the unusual nature of this case, there have been 64 cases in the last 5 years nationwide in which defendants under 21 have been prosecuted for child pornography, and that is within the last 5 years. So it's not unheard of, but it's certainly unusual. You're also a first-time offender, which is an important consideration. You have no known criminal history, and as the psychological report concludes, there's no reason to believe you're a pedophile. There is no reason to believe you are a pedophile or that you pose a risk to children, nor is there any indication of dangerousness in your background. Indeed, you have been heralded in the past as a model student and a youth leader, and a youth leader, and a youth leader, and a youth leader who has graduated from high school, who has been accepted to college, and who was on your way to becoming a productive member of society. It is tragic that you permitted your curiosity to jeopardize all that. The court is taking into account that your youth and inexperience may have clouded your judgment regarding this behavior. I also believe in your written expression of remorse and your statement today, and I note there is a risk that you could be vulnerable if you're required to serve a long period of time in prison because of your youth, inexperience, and general nature. All these reasons are good reasons to vary downwards from the guidelines range in this case. The next factor I want to address is the purpose of punishment. As I've mentioned, there are many purposes that are listed in the statute The first of which is that a sentence should reflect the seriousness of the offense, promote respect for law, and provide for just punishment. I will not say more than I've already said about how serious the offense is. I think you understand, but what I want you to understand is the sentence I impose here today must reflect that seriousness. Okay, let's just let that sit for a second. Let's let that sit for just 1 second, all right? I want you to understand the sentence I impose here today must reflect that seriousness. Now, we have seen her many times describe how this is serious in varying words of adjectives. Extremely serious, extraordinary serious, very serious, and other things. And she says the sentence must reflect the seriousness. So we must conclude the sentence does reflect the seriousness. And therefore, this is exactly 3 months of serious. $2. It is K-U-R-T. It is K-U-R-T. Like Vonnegut, or cocaine, or Cobain, or Russell, or, yeah. I'll be fine, Stephanie. $10 from somebody. Thanks for covering this. You're welcome. This doesn't necessarily mean that harshness is required, only justness. And a fair and just sanction is that one that balances both the seriousness of the offense, in this case, the mitigating circumstances of the offender. Another purpose of sentencing is to deter future crimes of the defendant and others. As long as we're doing a point of legal education, I guess, deter the future crimes of defendants and others. This is deterrence in two flavors. So you'll sometimes hear deterrence as a reason to prevent, as a reason to punish. Deterrence comes in two flavors: general deterrence and specific deterrence. The difference between general deterrence and specific deterrence is whether is the defendant versus the world, right? General deterrence is the world. Specific deterrence is the defendant. So one of the reasons to punish a defendant is to deter them specifically. That would be specific deterrence. One of the reasons to punish the defendants would be to deter others. That's general deterrence. So as long as we're having a discussion, we can talk about the difference between general deterrence and specific deterrence. And that's the difference between general deterrence and specific deterrence. Stephanie says you're allowed to worry about me. You are allowed to worry about me, Stephanie, and it is appreciated as always. I know I will never, I hope I will never stop you from worrying about me. But I know that you're in my corner. I appreciate it. Carrying on. Defense counsel has argued in the sentencing memorandum there is no empirical connection between long prison sentences and recidivism. I mean, I don't know whether there is or not, to be honest. This may be so, and the court does not believe that you, Mr. Hawkins, are destined to repeat this crime unless you spend time in jail. I will say, however, that regardless of whether a particular offense is low recidivism risk, the punishment also serves as a general deterrent. So this is the difference between general deterrence and specific deterrence. So this is a technical distinction for what it's worth. $10 from Dimitri Keller. Thank you. I will say, however, that regardless of whether the particular offender is low recidivism, the punishment also serves as general deterrence, a warning to others who might be considering the behavior at issue that it's not okay to break the law in this manner. And there will be consequences if one decides to possess or peddle in child pornography. Those consequences are causing me to shake in my boots, let me tell you what. I think I have enough leave accumulated at work to count for that time. Damn. This court believes that despite your low risk, there's still a deterrent factor that's present and must be considered when fashioning a sentence in this case. The other purpose of sentencing, including protecting the public from future crimes, that is isolation and incapacitation, and providing the defendant with educational and vocational training and rehabilitation, that's rehabilitation, are not major factors in this case. So protecting the public is not a fact. She literally just said, guys, it's on screen. Read it. She literally just said protecting the public from future crimes is not a factor in this case. Protecting the public is not a factor in this case. Okie dokie. No one argues, Mr. Hawkins, that you pose a threat to anyone. It's not necessary to incapacitate you in order to protect the public. It also appears you're educated, that you've done well in education in the past, and that with the exception of some limited mental health treatment, your rehabilitative needs appear to be minimal. The final factor I wanted to mention under the relevant statute is the need to avoid unwanted sentencing disparities. It is significant, as defense counsel pointed out, the government has requested a substantial downward departure in this case. That doesn't happen often. I mean, they're already giving you one hell of a break. They're basically offering quarter time. I've also reviewed statistics relating to the sentence of child pornography defendants, both nationwide and in this district. People need to absolutely get Nick Rekieta to respond to this. I'm going to harass the fuck out of Nick Rekieta. Nick Rekieta absolutely has to fucking read this. He has to read the whole fucking thing. Because he's fucking obligated. So this is available. I will send him a copy. He needs to read this thing on stream and fucking tear his eyes out too. Everyone tell Nick he has to read this. Didn't he already? No. Not unless I know something, not unless you know something I don't know, because no one had the fucking transcripts. No one had them. Nobody had the transcripts. We've been looking for them forever. Nobody had the transcripts. They were all sealed. The sentencing memorandum was sealed. Nobody had it. If Nick did this on stream, it's news to me, because nobody fucking had it. Nobody had it. We couldn't get it. We couldn't get it. The court is satisfied that a significant downward variance from the guideline range would not create unwarranted disparity in sentencing of defendants who commit child pornography offenses. You've probably heard some quotes. You've probably heard some chief quotes from this before. So yeah, you've probably heard some chief quotes because the senators had a copy of this. So the senators had a copy of this. So particular quotes, particular sentences you might have heard before. So maybe that's what you're thinking of. But like no one in the public had a copy of this. Nobody in the public had a copy of this. Yeah. Conservatives on campus, it's shocking to me she's leaning on these crimes, I know. Do we know how we have it now, FOIA? I don't know how we have it now, to be honest, nor do I fucking care. And it's not FOIA. Because the transcript is not scheduled to be released until July 4th. It is scheduled to be released, but it's not scheduled to be released until July 4th. So, We're 3 months ahead. Worked out well for us. The unbreaded has nothing on this. The unbreaded has nothing on this. I will note, however, in regards to this particular case, that Mr. Jeffries has cited both in his memorandum and here today, many, if not all, the probation statements that were mentioned were issued by the same judge in the same district, whose view about child pornography may differ from my own. Yeah. So as you can tell from my discussions of some of the relevant statutory factors, there are a lot of considerations to be taken into account. In this case, the court concludes the factors cut both ways. Yeah, Article 3 has it. That's where I got it. Article 3 has it. I don't know where they got it, nor do I care. On the one hand, Mr. Hawkins, you have committed very serious and in many ways heinous crimes, one that capitalizes on the victimization of the most vulnerable members of society. I would have mentioned it. I just simply forgot. So thanks for reminding me. I mean, I wasn't trying to hide it. I just simply forgot where I found it. But Article 3 is where I found it. I have to be mindful of the victims of child pornography as I assess the nature and characteristics of this offense. And I kind of even express adequately how horrifying it is for me to know that somewhere out there are children who are being trapped and molested and raped for the viewing pleasure of people like yourself. Also weighing in factor of a substantial penalty. Okay, I'm going to hang myself now. I'm going to hang myself now. And what did it was the sentence. Also weighing in factor of a substantial penalty. Also weighing in factor in favor of a substantial penalty. Is the need for general deterrence, which, as I said, means not necessarily deterring you as an individual, but deterring those who otherwise might be your case. Okay, that's what fucking general deterrence means as a technical matter. That's what general deterrence is, technically, as opposed to specific deterrence. It doesn't mean deterring you. That's not what general deterrence is. General deterrence is deterring literally everyone else. Specific deterrence is deterring you. It's a technical distinction. Fucking bullshit. On the other hand, you yourself are not much older than children in these photos. In the videos you possessed, I mentioned, you were viewing sex acts between children. You were viewing sex acts between children who were not much younger than you, who were not much younger than you, who were not much younger than you, who are not much younger than you. And it's clear from the record your interest was in part motivated by your lack of maturity and was of limited duration. I do not believe you are similar in intent or as culpable as some of the depraved older adults who have committed this crime and who engage in the kind of behaviors I talked about. And I do find, as I've said, a substantial variance downward from 97 months, which is the guideline minimum, is warranted. So the question becomes then, how much of a downward variance? The government urges the court to impose a sentence of 24 months of imprisonment. But I am not persuaded that 2 years in prison is necessary to achieve the purposes of sentencing in this case. That term of imprisonment would reflect the seriousness of the crime, But specific deterrence, that's you, incapacitation, which is preventing you from doing other things, and rehabilitation, which is making you stop doing it in the future, of this particular defendant are not issues. And a 24-month sentence does not adequately account for the extraordinary mitigating circumstances of Mr. Hawkins' age, family circumstances, and future potential. Defense counsel has requested this court impose a sentence of 1 day of imprisonment followed by home detention, but the court has difficulty in seeing how this term is sufficient to recognize the seriousness of the offense and to promote respect for federal law criminalizing possession of child pornography. While it is true you had not yet amassed a large collection, and apparently 16 images and 17 videos is not a large collection, so I need to step up my game, I guess. $10. I know I'm behind, but he shouldn't get caught as long a sentence because they caught him too early. This is BS. Also, don't give Kurt about trying to bring levity to something so hard for him to discuss. You gotta try to find ways where you can, man. While it's true you had not amassed a large collection, there's no evidence you engaged with anyone other than the There's no evidence you engage. I could do it. I can do it. $2 from Dagnixi Proceed. Did the people voting on our confirmation have it? They had it. They've had it for weeks. I have it now. Yeah. I can do this. While it's true you have not yet amassed a large collection, there's no evidence you engaged with anyone other than the undercover officer you did a search for and knowingly received a number of horrible videos. You knew what you were doing, and you know what you were doing is wrong. This is truly a difficult situation. I appreciate your families in the audience. I feel so sorry for them and for you, and for the anguish this has caused all of you. She's apologizing to him. This had been reported before, by the way. That she apologized to him. She's apologizing to him. She is apologizing to him. She is apologizing to him. Let's read it again. This is truly a difficult situation. I appreciate that your family is in the audience. I feel so sorry for them and for you and for the anguish this has caused all of you. So, I missed your super chat. Why were they sealed in the first place? Well, I can help you on that one. As I become very inebriated, but I can help you. Okay. So. If it's part of a plea, the sentencing memorandums are always sealed. As a matter of policy, they're always sealed. And the transcripts were never ordered in the first place. I don't know how the committee got them 2 weeks ago or 3 weeks ago or 4 weeks ago, but the transcripts were never ordered. The transcripts have been ordered now, but that's why. I mean, the transcripts were never ordered, and the sentencing memorandums, they're all under seal. They all are. In every single case. All 8 of them. They were all pleas. And every single one was sealed. All of them. All of them. That's why I also feel terrible about the collateral consequences of this conviction. I'm going to make it through this. I can do it. Mr. Jeffries mentioned that sex offenders are truly shunned in our society. Well, that's a shame. That's unfortunate. I mean, sex offenders are shunned? I mean, that doesn't seem right, does it? I mean, we as a society should do better. We should do better. That we shun these sex offenders with the possession and the distribution of the child pornography, the sadomasochistic child pornography with the 8 and 10 and 12-year-olds engaged in rape. I mean, that we would, as a society, shun them? I mean, but I mean, the judge is kind of wrong. The judge is kind of wrong, actually, because as it turns out, we don't shun them. You know what we do instead? We give them jobs in IT. Washington Daily says, my question is, when were they sealed? They were sealed instantly. It'd be suspicious if they're sealed right before Biden released her as a pick. That would be. But that isn't the case. It isn't. They weren't sealed right before Biden came as a pick. They were all sealed from birth. They were all sealed instantly. They were all sealed the moment they were created. All of them. Whatever I do, that is going to happen. And what I have here to fashion a just sentence is based on what you've done and what the law requires. My analysis of the factor leads me to the conclusion. A lengthy term of imprisonment is not warranted, but some prison is appropriate here. The just sentence is one that allows you, Mr. Hawkins, spend enough time in prison to understand and appreciate the consequences of your actions. Okay. In getting involved in possessing and viewing child pornography, and develop an aversion for committing any crime of any sort, but not so long as you will be subject to harm in prison, or introduced to incorrigible influences such that you're lost to society forever. You had and still have so much promise, and the sentence the court imposes has to reflect not only your bad conduct, but also the hope you'll find a way to contribute meaningfully to society tomorrow, for yourself, for your family, and for your community. As I've said, I've done my homework. She's thought about it. She's given her due consideration, as she should, as a federal judge. Harvard undergrad, Harvard Law School, Harvard. Federal judge. She's done her homework. I've looked at the sentences that have been imposed. The average sentences for defendants were under 21. The average sentences for defendant both nationally and in the district where the offense level is the same as yours. I've cut the data in many ways and considered all the factors, as I've said. And here's where we reach the moment of truth, my friends. This is the moment you've all been waiting for. This is the moment it all comes together. This is the moment where we reach the just sentence. This is the moment where we accomplish the goals of our prison system and we ensure that we give the sentence that is due. This is the moment of truth. I want you to soak it in. Soak it in deep. It is my conclusion that 3 months of imprisonment, followed by 3 months of home confinement with special limited conditions, including that you be allowed to participate in sex offender treatment and mental health treatment, strikes the appropriate balance and is sufficient, but not greater than necessary, to achieve the purpose of sentencing in this case. Well, man, round of applause, man. Round of applause. We've achieved justice, man. We've achieved justice. We have found the appropriate sentence for this case, man. Boy, howdy. Wow. We have got it down. Man, 3 months. Woof. We got it. We got it. It took 48 pages. 48 pages. 48 pages it took us, but we finally got it. We got what we wanted. In fact, I want to read it again. Don't you? Don't you want to read it again? I know you do, because it's so great. Why wouldn't you want to read it again? Let's read it. Let's read that glory moment again. It is my conclusion, preach it, that the 3 months of imprisonment, followed by 3 months of home confinement with special limited circumstances, including that you be allowed to participate in sex offender treatment and mental health treatment, strikes the appropriate balance and is sufficient, but not greater than necessary, to achieve the purposes of sentencing in this case. Glorious. Glorious. Therefore, based on my consideration of these and other factors, as I stated, I will now informally impose the sentence to be imposed. It is the judgment of this court that you, Wesley Hawkins, are hereby committed to the custody of the Bureau of Prisons for a term of 3 months on count 1. Yes. Yes. You are further sentenced to serve 73 months of supervised release, the first 3 months of which will consist of a period of home confinement and you must pay $100 of special assessment. The court finds you do not have the ability to pay a fine and therefore waives imposition of a fine in this case. The special assessment, which is $100, is immediately payable to the clerk of the court for the U.S. District of Columbia. Wow. $100. $100. Wow. Eric from Wisconsin says Kurt is drunk. Kurt is not drunk enough. Kurt is not drunk enough for this. To try to make the pain of the $100 special assessment go away. Woof. Woof. Within 30 days of a change of address, you shall notify the clerk of court of change until such time as financial obligation is paid in full. That would be the $100. Within 72 hours of release from custody, you shall report in person to a probation office in the district to which you're released. While on supervision, you shall not possess firearms or other dangerous weapon. You shall not possess an illegal controlled substance, and you shall not commit any federal, state, or local crime. shall also abide by the general conditions of supervision adopted by the U.S. Probation Office, as well as the following special conditions. You will be restricted to your residence at all times for a period of 3 months. The first 3 months of supervised release term, except for medical necessity, mental health treatment, sex offender treatment, and court appearance, or other activities that are specifically approved by the court. You shall comply with sex offender registration requirements for conviction of sex offenders in any state or jurisdiction where you reside, are employed, carry on vocation, or are a student. You shall have no direct or unsupervised contact with minors under the age of 18 without written approval of the United States Probation Office. Kurt needs coffee. Yeah. You shall not be employed in any capacity or participate in any voluntary activity which may cause you to come in direct or unsupervised contact with children, except under circumstances approved in advance by the United States Probation Office. Pursuant to the Adam Walsh Child Protection and Safety Act of 2006, you shall submit to search of your person, property, home, residence, vehicle, papers, computer, other electronic communication, or data storage device or media and effects at any time with or without warrant by any law enforcement or probation officer with reasonable suspicion concerning unlawful conduct or violation of condition of supervision. You shall participate in a program of sex offender assessment and treatment as described by the United States Probation Office. At the direction of the United States Probation Office, you shall pay for all or portion of any treatment program. You shall waive your right to confidentiality in treatment and sign any necessary releases for any records imposed as a consequence of this judgment to allow the United States Probation Office to review the course of treatment and progress with treatment providers. You shall submit to polygraph testing as directed by the United States Probation Office. At the direction of the United States Probation Office, you shall pay for all or portion of polygraph testing if it is ordered. Pursuant to rule of the Federal Rules of Criminal Procedure, you, Wesley Hawkins, are ordered to forfeit the following: a Toshiba laptop of a specific serial number with a hard drive of a specific serial number, and a cellular telephone with a specific IMEI, I apologize. The probation office shall release the pre-sentence report to all appropriate agencies in order to execute the sentence of this court. Treatment agencies shall return the pre-sentence report to probation office upon defendant's completion or termination from treatment. Thank you, Kyle. That's very kind of you. Finally, you have the right to appeal the sentence imposed by this court if the period of imprisonment is longer than the statutory maximum, which is not, or the sentence departs upward from the guidelines range, which is not. I'm required to notify you of the right to appeal nevertheless, and if you choose to appeal, you must file any appeal within 14 days after the court enters judgment. If you are unable to afford the cost of appeal, you may request permission of the court to file an appeal without cost to you. Now, counsel, I don't know whether this prison term is long enough to trigger Brisa Pura's placement analysis, but it may be. Do you know whether such a term would involve placement? Your Honor, I assume we're going to do voluntary surrender? The court, we are. I think it will be placed in Bureau of Prisons. Then would you like me any recommendation? Can I approach the government? Yes. They approach the government. Your Honor, we're still bitching. Unbelievable. Your Honor, I have serious concerns about this defendant in the Bureau of Prisons. He's not eligible, as I understand the BOP regulations. He's not eligible for a camp. So we're talking about something above minimum security. I don't know what can be done. Maybe there's nothing can be done. But I think I'd like to do is, the reason I'm doing it at the bench, I don't want to horrify the family anymore. But given his appearance, his emotional state, everything, I guess I'd like to go back and look if there's something a way to do recommend the Bureau of Prison do something that can assure safety. Miss Pinninger, are you aware of anything that we can recommend? I'm not. I have very recently in another case, in another matter, spoken with the placement people of the Bureau of Prisons, and certainly willing to reach back out to them and see if they have any copy of the regulations. My understanding is there's a number of factors they evaluate. I read the things that Mr. Jeffrey submitted, and it's not totally clear to me whether just the offense alone ensures that. It seems to me Mr. Jeffries is not disputing that. I'm saying I'm happy to call and try to find out the answers. Right now, I don't know. I haven't personally inquired of them. I know that when I spoke with the Bureau of Prisons about another sex offender inmate who had raised some concerns, there were different issues, that I spoke with him and went through some factors that were not. The question we're addressing was not specifically this, whether he was going to a camp or not. I'm certainly happy to follow up, Your Honor. I'm happy to. There are places they send, like police officers who've been convicted of crimes, things like that, which is enhanced, emphasis on safety. Here, the main concern is, I think, sexual. I guess what we'd like to do is go look at, talk to the Bureau of Prisons and see what they think the best recommendations are for us to give to you, and then put that in the judgment. The court, I'm happy to do that. I think the judgment, usually I issue it in a couple of days. So if you could do that quickly, I'll make whatever recommendation you think is appropriate. Sure. Okay. I'm happy to call the Bureau of Prisons. Okay. The court, Mr. Hawkins, I will allow you to stay out of jail pending surrender. Good. It's good. It's fine. No problem. Why not? You've been on high-intensity supervision and will continue until the time to report to jail. Mr. Jeffries, did you have something you wanted to? Yes, Your Honor. I think in terms of supervised release conditions, the only one, the language in this one, the contact restriction states, I think with the court read, I've seen this in other cases, not my own, but it says, you shall have no direct and or unsupervised contact with minors. Why doesn't this just say you shall have no unsupervised contact? I don't really understand. You shall have no direct or unsupervised. So even if he can't have direct, that's supervised. I'm not sure what. That's a standard condition that's ordinarily put in. I think that's attempting to address a situation which is a lack of supervision, but I don't have a problem with removing direct and or, so it reads you shall have no unsupervised conduct. Is that the point you're trying to make? Yes. We have permission. Let's see. The government has no objection. Okay. Thank you, Your Honor. So we'll strike that. I was talking about voluntary surrender. Mr. Hawkins, $20 from Eric from Wisconsin. I'm drunk too. I deny the premise. The premise is I'm drunk, which I deny. Buy a partial bottle of scotch. I'll give more, but we need food for the upcoming recession. Well, thank you very much for your $20 super chat. It is appreciated. You are required to appear for surrender as directed by the probation department. The court does not control when that happens, as directed by probation and the Bureau of Prisons. Failure to appear as required is a separate criminal offense for which you could be sentenced. If you fail to appear, you'll be subject to fine or imprisonment as additional terms of imprisonment that will be consecutive to the sentence you receive. Also, all the conditions on which you are now released up to now apply, and the penalties for violating these conditions can be severe. If you violate any of the conditions, you'll be subject to revocation of the release and subject to prosecution for contempt. In addition, if you're convicted of another offense while you're released pending surrender, then in addition to the sentence imposed for that offense, you'll be sentenced as well for having violated conditions. Any term of imprisonment for offense committed on release will be consecutive to a sentence for violation. Do you understand? Defendant, yes, Your Honor. Okay, counsel, is there anything further? No, Your Honor, thank you. Mr. Jeffries, thank you. Thank you. Good luck, Mr. Hawkins. I'm sorry about the circumstances and hope you'll be able to put this behind you after punishment imposed. Whereupon, at 11:19 a.m., the proceedings concluded. Well, my friends, that is the end of the thing. And That was a lot. That was a lot of things. $19.99 from Urine Selffoot. Thank you for covering this. You're welcome. Kurt, is this justice in your opinion? I have to respectfully say no. Going extreme? I'm good. Nick, heard from chat. You got the transcript? Go hit him up. He's streaming now. Okay, I'll do that. I'll go hit him up. Streamlabs reminds you of the important details just now. Streamlabs. If you're not subscribed, hit the subscribe button. If the red button is red, you need to subscribe. You can also hit the link or the join button, the link that Streamlabs just told you about, to become an uncivilian for 99 cents a month. Help to support the channel. Help to make it grow. And, yeah, I'll go, I'm going to go troll in Nick's chat for a while. So you can check me out there. I'm going to go troll in his chat for a while. And, yeah, I'm going to make him read this and get really fucking drunk. What would Judge Kurt sentence the defendant? I honestly don't know. My first thought is go with the government's recommendation of 24 months. I mean, it's a pretty big break already. But, you know. But yeah, I'll go hang out on Nick's chat for a little bit. I'll go harass his chat. I doubt I'll join the chat. I doubt I'll join the stream. Unless he really wants me to, which would be hilarious. But I'll go hang out on his chat and troll it for a little while. Yeah, I'm gonna go over to Nick's chat, at least troll his chat for a little while, and then I'll go pass out on the couch or something. I'm gonna sign out for now. Until later, my friends, I hope all is well. Cheers. Good night.